Hi, I'm Gina Johnston.
And I'm Thomas McFarlane.
And we are Senior Associates in Dispute Resolution and Litigation Team at Shepherd and Wedderburn.
In this video, we're going to be discussing the general progress of a court action. As we detailed in our previous video in this series in relation to the Scottish court system, there are a number of different courts and tribunals in Scotland, each with their own jurisdiction, as well as particular rules and procedures. It is beyond the scope of our video series to look at all of those in detail. However, broadly speaking, all types of court action in Scotland follow a similar procedural flow in relation to pre-action, commencement, service, defences and ultimate disposal of the action, including via judicial determination. In this video, we will provide a high-level overview of this process with reference to the typical Sheriff Court and Court of Session procedures. The graphic on screen shows the typical progress of a commercial action in the Court of Session, which will be broadly similar for all actions in the Sheriff Court and Court of Session. Prior to raising a court action, and unless there is some urgency or time limit, then parties should always attempt to resolve the matter between themselves first. Indeed, the vast majority of disputes are resolved prior to court action being raised, either through correspondence, face-to-face meetings, or by alternative methods of dispute resolution, such as mediation. Only a very small percentage of disputes end up in Scotland's courts and tribunals. There is no compulsory requirement to engage in pre-action correspondence, but parties in commercial actions are directed to do so by the courts. In such cases, and where possible, parties are expected to exchange correspondence, setting out their respective positions, and providing each other with any documents they seek to rely on, including any expert report. If a party fails to do so, the court can take this into account when considering expenses.
In the Court of Session, an action is commenced by way of summons or petition. A summons is used where a pursuer is seeking to establish and enforce a right against a defender. A petition, meanwhile, is used where the authority of the court is required to do something. In the Sheriff Court, an action is commenced by way of initial writ, or in some cases, summary application or summary cause summons. In simple procedure claims, that is for claims of £5,000 and under, the action is commenced by way of a simple procedure claim form, which is populated by the pursuer. In all cases, the pursuer will have to draft and then lodge the appropriate document with the relevant court and pay the relevant court fee. If satisfied, the court will then provide the pursuer with authority to proceed with service of the action on the defender or defenders. This is commonly referred to as warranting in the Sheriff Court or signating in the Court of Session. Service of a summons can be made in a variety of ways. Parties must comply strictly with the rules in relation to service in order for valid service to be effected. Usually service is made by registered post or by personal service at the hands of sheriff officers, in the case of the Sheriff Court, or messenger at arms for the Court of Session. They are officers of the court and akin to process servers or bailiffs in England and Wales. A defender must be given a minimum period of notice of a claim against them. If the defender is based in Europe, the period of notice given is 21 days. If the defender is based further afield, the period of notice is 42 days. There are some exceptions where a reduced period of notice might be allowed. An important point to bear in mind is that service is needed to stop the prescriptive clock. A court action must also normally be served within a year and a day after the court has warranted or signated the action. If it is not served in time, then the authority of the court is lost and the pursuer cannot proceed. If you're not time barred, then a fresh action can obviously be raised. We consider prescription, otherwise known as time bar, and in more detail in a separate video in this series. How long a defender will have to lodge defences will depend on the court and the type of action. In Court of Session actions involving a summons, including commercial actions, there is also an additional step in the procedure before defences are lodged. The summons must be lodged for calling following successful service. This involves returning the signated summons to court with a certificate of service to formally activate the case. The summons must be lodged for calling within a year and a day of the end of the period of notice, otherwise the instance falls and the pursuer cannot proceed with the case. Once the summons has called, a defender then has 3 days within which to confirm to the court that they intend to defend the action and 7 days to lodge defences. There is no need to lodge for calling in a Sheriff Court action or petition procedure in the Courts of Session. In the Sheriff Court, defenders have up until the date of expiry of the notice period to confirm to the court if they intend to defend the action, and they do so by way of lodging a notice of intention to defend. If they do so, they then have an additional 14 days from the expiry of the notice period within which to lodge defences. In simple procedure claims, defenders must lodge defences with a certain date, which is detailed in the court documents. Defences in petition procedure are known as answers and normally require to be lodged by the expiry of the period of notice. If a defender fails to lodge defences timeously, then decree or judgment may be awarded against them in absence. Once defences have been lodged, a period of adjustment is then normally allowed for parties to adjust their respective written pleadings. There are formal rules and expectations around how parties plead depending on the type of action and court. We consider this in more detail in a separate video in this series on written pleadings. The period of adjustment may be extended with permission of the court. If parties seek to alter their pleadings after the period of adjustment, they are required to do so by way of amendment, which requires leave of the court, and, as we will discuss in more detail in our video on written pleadings, a party seeking to amend will generally require to bear their opponent's costs for considering the amended pleadings.
How a court action will proceed thereafter will depend on the form and content of the pleadings. Parties will need to consider what further procedure there should be in the case, and if they cannot reach agreement, the court will decide. There are four main options: to allow further time for the parties to adjust their written pleadings, including time for further investigations. The case can be sisted, whereby it's put to sleep procedurally for a specified period and for a specified purpose, normally for the parties to explore the potential for settlement or to allow for further investigations. A legal debate is fixed. This is where preliminary legal issues are argued without evidence. For example, there may be an argument that even if all that is pled by one party is proved correct, it is insufficient or irrelevant in law to support the orders they are seeking, or a proof or proof before answer might be fixed. This is the equivalent to an English trial, where there is a full hearing on the facts of the case. Sometimes legal arguments require the facts to be established first, before questions of law can be considered, so a hearing called a proof before answer will be fixed. This is where the court hears evidence before hearing legal submissions and then making a judicial determination. We consider in more detail debates, proofs and proofs before answer in our separate video in relation to pleadings. Questions are also likely to arise regarding the recoverability and leading of evidence in a case. This may be by way of witness evidence, skilled or expert witness evidence, as well as documentary or physical evidence. We consider recovery of evidence, including in relation to disclosure and dawn raids, in our separate video on recovery of evidence. We also discuss evidence, including documentary witness and expert evidence, in separate videos as part of this series. Once the court has heard the parties at a substantive hearing, either at a debate, proof or proof before answer, the sheriff or judge will make a determination. In some cases, a decision will be rendered immediately, whilst in others, the sheriff or judge will go away to consider the evidence and legal arguments. This is called avisandum, which simply means to take time to consider a case and reach a decision. At a debate, the court may reject all of the debate points, in which case the action is likely to move on to a proof, which is a hearing on the evidence. Otherwise, some or all of the debate points may succeed, which could mean that decree or judgment is awarded in favour of the pursuer, or that the court action is dismissed. The court may also restrict the matters which can be heard at proof to remove irrelevant arguments or evidence. Following a proof or proof before answer, the court may find for the pursuer, in which case decree will be granted for the orders sought. Otherwise, the court may find for the defender, in which case the court will grant decree of dismissal or decree of absolvitor, both of which bring the action to an end, but there is a distinction in law between the two. Decree of absolvitor means that the same action cannot be re-raised, unlike decree of dismissal. In general, where a party obtains a decree or judgment in their favour, they will also obtain expenses. Expenses are covered in more detail in a separate video in this series. If a party is unhappy with the decision of a judge or sheriff following a debate or proof, then they may reclaim or appeal against that decision. We consider the appeals process in detail in a separate video in this series.
We hope you found this high-level video on the general steps in a court action of interest.
If you have a dispute on which you require legal advice, please do get in touch.